Spell your last name.
Theberge, Theberge. Good evening. We, the residents of the Commonwealth, are counting on you, the DPU, as well as the Department of Energy Resources, both taxpayer-funded, to look out for the rights and well-being of all residents. We're counting on you to be savvy to the ways energy corporations present their cases. We need you to hold these corporations' feet to the fire, most especially at this critical moment in the climate crisis. However, we fear, as we read the documents in this docket and in 2 other cases before the DPU, that may actually help to decide whether or not the proposed NED pipeline will be built, that you, our public servants at the DPU and DOER, are primarily accepting the gas company's cases at face value. The DPU made a recent decision, which Katie just spoke to, that is an example of how your decisions are being affected, are profoundly affecting us. And this was the decision about intervener status. This decision specifically was the hearing officer's exclusion of Representative Steve Kulik and Plan from having intervener status to fully participate in the proceedings throughout this case. The town of Montague, as represented by its select board, and the town council of the town of Greenfield are among many legislators and officials who represent the interests of municipalities and large constituencies of ratepayers and residents that do not have any other representation in this docket that would link our specific concerns to the heart of Berkshire's case. The appearance that the DPU in this docket is acting to avoid a thorough examination of this company's proposed contract with NED begins with the schedule. The hearing officer issued the schedule on May 29th, the same day she issued her decisions on which organizations would be full interveners in the proceedings and which not. Interveners were at the same time given only 1 week to investigate and respond to Berkshire Gas's case and to deliver testimony to the hearing officer. This despite the fact that no outside participant in the case had the right to see the key financial and engineering data Berkshire is using unless they're given intervener status. This critical information is redacted. It's being hidden from public view. Most of the actual contract between Berkshire Gas and NED is also redacted. So the center of the whole proceeding was not available to interveners until 1 week before their deadline to present a full investigation, analysis, to challenge and to provide possible alternatives to this contract, of which there are many. This timetable inevitably undermines any thorough analysis of Berkshire's case, and it greatly weakens participation by any intervening party that cannot afford to pay multiple expensive lawyers and consultants, like certain corporations, to work around the clock.
Sobelman, S-O-B-E-L-M-A-N.
And can I please remind everyone of 3 minutes, please?
Others have pointed out tonight that the Conservation Law Foundation and intervener in all 3 of these gas company dockets requested just 1 more week to prepare testimony and was denied by the hearing officer, Ms. Wiseman, who is with us here tonight. Her ruling included the interesting comment that her reasons would become clear in her later rulings on substantive issues in the proceedings. To us, this sounds like the DPU has already prejudged these cases, something that Representative Kulik pointed out as well. And we don't see any sign that any prejudgment is about NED being a poor fit for the public interest, which of course we would support because we find this to be the overriding truth of the situation. Now we come back to the role in this docket of Representative Kulik and Plan. We urge the DPU commissioners to grant Plan's appeal for full intervener status. The hearing officer stated that the members of Plan are not substantially and specifically affected by this proceeding. Nothing could be further from the truth. Every one of the state legislators and municipal officials and individuals who have joined Plan did so on behalf of thousands of constituents who have no other voice in this docket and who are substantially and specifically affected in multiple significant ways. There is not time here to list the many impacts on Plan's member constituencies that Plan uniquely represents in this case. Let us touch on just one issue others have discussed that is of great concern to Montague, Greenfield, and Amherst, all of which are represented by Plan. This is Berkshire Gas's moratorium on new gas service, which the company claims must continue for nearly 4 years and claims it cannot alleviate by any of the solutions this 162-year-old company would normally use to cover a shortfall. Interestingly enough, Columbia Gas Company, which also has a docket open to buy Ned Gas, seems to have lost its corporate skills at preventing shortfalls and making up for them when they occur at the same time as Berkshire Gas did. So I and my neighbors in Northampton are burdened with an identical moratorium. What an unusual coincidence.
Ariel Elan, E-L-A-N, Montague resident impacted, Montague, Massachusetts resident. My colleagues just referred to the rejection of Conservation Law Foundation's modest request for just one more week to prepare testimony, and that applied actually to all of the NED contract dockets that are currently before the DPU. There are three of them. And Conservation Law Foundation, CLF, did not even, sorry, the sound is hard, did not even ask for an extension of the full time for the proceedings, just 1 week delay. Well, they didn't get their extra week, but what was terribly interesting is a letter from Mr. Avery, the attorney for Berkshire Gas, who is here tonight. Berkshire Gas's objection to giving CLF an extra week to prepare testimony, I'm reading from his letter. CLF's motion should be denied because CLF, by its own admission, has known for over 4 months about a parallel proceeding in New Hampshire concerning the approval of an essentially identical precedent agreement. Essentially identical precedent agreement? Really? In New Hampshire? For a completely different company that files completely different forecast and supply plans under completely different regulations? Identical agreement. And it's not a mistake. This language is repeated. I'll read you another paragraph. Tennessee, this is Attorney Avery from Berkshire Gas who's with us tonight. He writes, Tennessee, that's the pipeline company, cannot proceed to the next step of the pipeline approval process for the NET project until it has first obtained sufficient contractual commitments from local distribution companies, such as Berkshire. Thus, Liberty Utilities, a New Hampshire local distribution company, is currently pursuing approval of an identical precedent agreement with Tennessee in the referenced parallel proceeding before the New Hampshire DPU. What this sounds like to me is that all 4 of these contract cases, Liberty in New Hampshire, Berkshire Gas in Massachusetts, National Grid Boston Gas in eastern Massachusetts, and Columbia Gas in Massachusetts, these cases may not have any credible basis in the individual supply plans and supply needs of these utilities. Are these cookie-cutter agreements? Were they pre-written and predetermined to get the Tennessee gas pipeline built? Chairman O'Connor, please look into this possibility as thoroughly as possible. And please, disallow all of the Massachusetts precedent agreements if you can confirm Attorney Avery's implication that these contracts are just corporate cover stories to get this pipeline built. Thank you.